Just a couple of loose ends. The relevant bits of the Companies Act which weren't included and the whole part of the Insolvency Act have now been copied. If we could hand those up.
That's very helpful. Thank you very much.
One point just occurred to us over the short adjournment that although I addressed you at some length on what we make of the de facto director analogy, I didn't mention one authority which is in the bundles but not referred to in our skeleton. So could I just mention, I don't ask you to go to it now, but could I mention Paycheck Services, which is in the authorities bundle at tab 38, and the relevant paragraphs are paragraph 39, 86 and 93. And the short point we take from that case is that in order to be treated as a de facto director, a person must be functioning as part of the corporate governing structure of the company, which is an expression used in several cases and approved by the Court of Appeal and I think by Collins in the Supreme Court. Yes, and Lord Collins in the Supreme Court. The other point that we were asked this morning was whether or not there was evidence at trial of the shareholdings of MBI International Holdings in JJW Inc., to which the answer is apparently yes, there was. There was a certificate of incumbency exhibiting the register of members showing MBI Holdings as holding 8.9 million shares roughly, and the company holding the 129,000 that you know about. And the last point I just wanted to pick up from this morning was that my Lord Justice Snowden questioned which was the actual IPO vehicle. Those with greater familiarity have checked back on material that's not in the appeal bundles, but was available at trial, and it does appear that JJW Inc. was the IPO vehicle. I'm not sure if anything turns on it, but I just wanted to report on the outcome of our investigations. So ground two.
Sorry, just before you go on, a quick question following up from what we were talking about this morning. In paragraph 518, the judge makes a finding that JJW is liable as a constructive trustee, and that is explicitly based upon it having received the 891k shares upon registration, and instead of failing to restore them to the company, transferring them on to MBI International Holdings.
Yeah.
Now that, as it seems to me at the moment, is flat inconsistent with the idea that registration was void. If registration was void, then JJW Guernsey cannot have received legal title.
Yes, I agree.
And cannot have transferred it on. So do I take it that you would accept that we should proceed on the basis that what the judge must have meant was that the signing by the Sheikh of the share transfer forms on or around the 29th of February 2016 was void, but not registration of JJW by as owner of the shares in JJW Inc. on the 8th of March?
Can I remain agnostic on that for the moment and get back to you with a commitment one way or the other?
Yes.
This is a complete side issue, I think. But would you accept that JJW Guernsey was a constructive trustee?
Well, on the hypothesis that we lose
breach
ground
of fiduciary
one.
duty.
Sorry.
If you committed a breach of fiduciary duty, then if the Sheikh committed a breach of fiduciary duty, it follows.
It would seem to, yes.
But it's dependent on that.
Yes, yes, it must be. Although I'm sure Mr. Fenimore will have more to say about that. Right, ground two. Can I just try and deal with this relatively rapidly by summarising some propositions and arguments, and then turning as lightly as I can to some quite detailed case law. In summary, the Sheikh's case is this. Point one, in quantifying equitable compensation, equity does not draw any distinction between so-called substitutive and reparative claims. In both situations, the function of equitable compensation is to put the trust fund, to use the term relatively loosely, in the position it would have been in but for the breach of fiduciary duty. And we would emphasize the way I have expressed that, is that in quantifying equitable compensation, equity does not draw any distinction between substitutive and reparative claims, because my learned friend in his skeleton says, yes, but there's lots of case law that uses these terms, which is indeed true. But they do not use the terms in order to produce different principled approaches to what equitable compensation is doing. There absolutely is a principled distinction between, on the one hand, a claim to disgorge a profit, which is, if one may call it, a gains-based claim, on the one hand, and a claim to put the trust back into the position it would have been in but for a loss caused by a fiduciary on the other. But that isn't the distinction we're concerned with. Second proposition, we submit that the diminution in the value of the 891,000 shares between the date of the 2016 share transfer and the date of the judgment would have occurred in any event as a result of the 2017 asset transfer, and it was not caused by the breach of fiduciary duty in respect of which the Sheikh was being sued. The third proposition is that, as a consequence of the first two, if this claim had genuinely been what my learned friend would call a substitutive claim, that is, to put back the trust asset which, but for the breach of duty, was lost, if that had been the true nature of the claim, the correct outcome would have been that the Sheikh would have been ordered to pay nothing, because the substitutive compensation would have been calculated by reference to the value of the shares, which the Sheikh was unable to deliver up in specie, or to restore in specie. And the value of the shares at the date of judgment was zero. So, fourth point, the liquidators obviously wanted to do better than that. So, properly analysed, their true claim was not substitutive. They were not asking for compensation calculated by reference to the value of the asset that would otherwise have been restored at the following judgment. They were asking instead for a money payment that was reparative, that is, seeking compensation essentially for the loss of the opportunity to realise the shares before the 2017 asset transfer occurred and took value out of them. They were not asking for restoration of the value of the shares at judgment. They were asking for compensation for losing the opportunity of selling the shares at an earlier date when they still had value. And the fifth and final point is that in relation to that claim, where the liquidators are asking the court to adopt a different valuation date other than date of judgment, the onus was on them to prove that the shares would have been sold before the 2017 asset transfer, and our submission is that there was no evidence capable of discharging that burden, indeed properly analysed against the correct legal test and the correct legal premise. All the evidence went the other way. So just breaking down, that's essentially a summary of the whole argument. Just the component parts, just spending a little bit of time on the law of relating to equitable compensation. Our propositions of law are first that the right of the Seti Quae Trust is to the proper performance of the trust. If trust property has been, second proposition, if trust property has been misapplied, the Seti Quae Trust can ask either for restoration of that property to the trust estate or equitable compensation. Third proposition, the purpose of any form of equitable compensation, as opposed to disgorgement of profits, the purpose of any form of equitable compensation is to compensate the trust fund for the trustee's failure properly to perform the trust. Fourth proposition is that two consequences flow. First, there must be a causal connection between the breach and the loss in respect of which compensation is being awarded. And secondly, it is axiomatic that the trust fund is never entitled to recover more than it has lost by reason of the breach. And the final point, in a sense, I've already anticipated when I was giving the summary of the whole argument, which is that as regards the date and the basis of valuing equitable compensation, the default position is that the amount of compensation is calculated by reference to the date of judgment, which is when the asset would otherwise have been returned, restored to the trust fund. The valuation is conducted at that date by reference to the value as at that date. And if the Seti Quae Trust wants to persuade the court to adopt a different valuation date, then he must prove that the asset would have been realised at some earlier date. Now, there's a string of authorities which are quite dense, and I don't think there's near time to do justice to them. But could I try and identify some key passages in the authorities? We blinked briefly at one of them, Canson, which is in the authorities bundle at tab 21. The Canadian decision. Authorities bundle at tab 21. If we could look at page 284. We looked very briefly at the bottom of the page about the underlying concept of the trust, being powers are opposed in the trustee, and picking it up there, the distinction between the rights of a claimant in equity for maladministration of property as opposed to wrongful advice or information resides in the fact that the former case equity can and does require property wrongfully appropriated to be restored to the Seti Quae Trust, together with an account of profits. Where there's no property which can be restored, restitution in this sense is not available. In those cases, the court may award compensation in lieu of restitution. This is a pragmatic distinction in the form of the remedy, which must not obscure the fact that the measure of compensation remains restitutionary or trust-like in both cases. Any further distinction is difficult to support. I commend all, although the sidelining is fairly comprehensive, but I was just going to move on to the next paragraph, just the last 4 or 5 lines by the letter G, still in the left-hand column on page 285. So equity awards compensation in place of restitution in specie by analogy for breach of fiduciary duty, with the idea of restoring to the estate that which was lost through the breach. Then if we can go on page 288. Just about letter H, there's reference to an earlier decision called Dawson, which we have in the bundles, and is also worth reading, but I don't have time. And then at letter I, the reasoning which the House of Lords, this is a quote from Dawson, the reasoning which the House of Lords adopted in Tompkinson's case proceeds on the basis that damages at common law are ordinarily not affected by subsequent fluctuations in currency exchange rates any more than ordinarily they are affected by subsequent fluctuations in market values. This reasoning is not available in a claim against a defaulting trustee, as his obligation has always been regarded as tantamount to an obligation to effect restitution in specie. Such an obligation must necessarily be measured in the light of market fluctuations since the breach of trust, and in my view it must also necessarily be affected where relevant by currency fluctuations since the breach. And still on that page at letter F in the middle of the paragraph, equitable compensation must be limited to loss flowing from the trustee's acts in relation to the interest he undertook to protect. Page 293. Between A and B, foreseeability is not relevant, but the last 3 lines, as a result, the losses are to be assessed as at the time of trial, using the full benefit of hindsight. So you take account of what has happened by the time of the trial. Target is at tab 23. Your Lordships, I imagine, are familiar with this. It's the solicitor who released funds before obtaining a charge, but a charge is then obtained, the borrower defaults, and the question is the solicitor liable for the full amount of the money released in breach of fiduciary obligations, or only liable for the loss that actually resulted from the breach committed, since a charge was ultimately obtained. The Court of Appeal's reasoning is sidelined on page 353, and I won't pause over that, but just so that you see where the Court of Appeal's reasoning, which is overturned, is outlined. And then if we just go on to 356. And between B and C, last 4 lines of the paragraph, accordingly, in the case of a breach of such a trust involving the wrongful paying away of trust assets, the liability of the trustee is to restore to the trust fund, often called the trust estate, what ought to have been there. And then between D and E, after referring to Nocton and Lord Ashburton, if specific restitution of the trust property is not possible, then the liability of the trustee is to pay sufficient compensation to the trust estate to put it back to what it would have been had the breach not been committed. And just after F, there does have to be some causal connection between the breach of trust and the loss to the trust estate for which compensation is recoverable, viz. The fact that the loss would not have occurred but for the breach. and 358 between C and D. But the basic equitable principle applicable to breach of trust is that the beneficiary is entitled to be compensated for any loss he would not have suffered but for the breach. And at E, to impose such an obligation in order to enable the beneficiary solely entitled, i.e. the client, to recover from the solicitor more than the client has in fact lost, flies in the face of common sense and is in direct conflict with the basic principles of equitable compensation. It's worth just noting the one-liner at G. The key point in the reasoning of the Court of Appeal is that where monies are paid away to a stranger in breach of trust, an immediate loss is suffered by the trust estate. As a result, subsequent events reducing that loss are irrelevant. That is the outcome the judge has produced in this case. And that is the outcome the House of Lords here overturned. And the judge goes on, Lord Brown-Wilkinson goes on to explain why that's the wrong approach on the next page. Critical passage between C and E. If I could just commend that without reading it. Just over at page 360, I'm sorry, I do have to take this relatively quickly. 360, you'll see there's lengthy citation from Campson, the case we've just seen. And at the top of 361, between A and B, in my view, this is good law. Equitable compensation for breach of trust is designed to achieve exactly what the word compensation suggests, to make good a loss in fact suffered by the beneficiaries, which, using hindsight and common sense, can be seen to have been caused by the breach. And there's another passage on 362 between D and E, which we would particularly urge on you, but I just want to try and pick up the most important. And then Target is followed some years later by AIB in the Supreme Court, Target having been the subject of some comment, not all of it favourable. So AIB is the opportunity of the Supreme Court, so tab 51. There's the opportunity of the Supreme Court to express a view as to whether a wrong turn was taken, which the answer was a resounding no. The Target is indeed good law. This was another case of money being released in breach of the obligations of the holder of the funds. And if we just pick it up at page 1136 in the bundle, we see the discussion at the top of 1136. The debate which has followed Target is part of a wider debate about equitable doctrines, so you see that the context without stopping unnecessarily. Page 1137. Paragraph 53, just by letter C, just below letter C, the term substitutive compensation has come to be used by some to refer to a claim for the value of a trust asset dissipated without authority. Hardly a ringing endorsement that it's a principle of importance to the approach to be taken.
To be fair, he precedes that by saying, according to legal scholars whose scholarship I have no reason to doubt.
Indeed. At letter E, in this type of case, the order for payment by the trustee of the amount of loss is referred to by some as reparative compensation, to differentiate it from substitutive compensation, although in a practical sense, both are reparative compensation. So, I mean, what one appears to be getting from that is that these terms are used, but they aren't in fact describing a difference of principle in the court's approach. And then the discussion of Target continues. I just want to mention the citation on page 1138 from Tipping in the Bank of New Zealand case, paragraph 60. letter H, just before letter H, the policy of the law in these circumstances is generally to hold the trustee responsible if, but for the breach, the loss or damage would not have occurred. And similar words are used. We get Canson again just at page 1140, paragraph 66. And paragraph 73 asks, having identified the question whether the Court of Appeal had broadly applied target, and the judge says, Lord Tewson says, this argument constricts too narrowly Lord Brown-Wilkinson's essential reasoning. Monetary compensation, whether classified as restitutive or reparative, is intended to make good a loss. The basic equitable principle applicable to breach of trust is that the beneficiary is entitled to be compensated for any loss that would not have been suffered but for the breach. And we then get Lord Reed over the page, who also endorses Canson. Paragraph 93, we get a reiteration, page 1146. We get a reiteration of the point that, putting the matter very broadly, he says, between D and E, compensation for the breach of an obligation generally seeks to place the claimant in the position he would have been in if the obligation had been performed. Equitable compensation for breach of trust is no different in principle. And we would urge on you at 1156 the general conclusions of Lord Reed, endorsing Canson and target, really the whole of paragraphs 133 to 136. And if I could just end in 136 between G and H. Of course, the aim of equitable compensation is to compensate, that is to say, to provide a monetary equivalent of what has been lost as a result of the breach of duty. Those principles were applied in the case of Ahmed, which is at tab 55.
Can I just pick up at 153? Lord Reed says you'd normally assess measure of compensation at the date of trial with the benefit of hindsight.
Yeah.
Loss must have been caused by the breach. So losses resulting from the unreasonable behaviour on the part of the claimant will be adjudged to flow from that behaviour, not from the breach.
Yeah.
The requirement that loss should flow directly from the breach is also the key to determining whether causation has been interrupted by the acts of third parties.
Yeah. Yeah.
Because that's what we're going to come on to, isn't it?
Not really, because it's not. This is not a case of a break in a chain of causation. Because if one starts from the principle that the duty is to restore the trust fund to the position it would have been in but for the breach, the answer is the position the company would have been in would be now to be the registered holder of the 891,000 shares. Those shares are valueless.
They are because of the acts of...
Because of a transaction which has not been impugned. The asset and liability transfer has not been impugned. So, and it is a fact. It is an event that happened. If you are assessing the value of the asset that would have been restored to the trust fund if it was available in specie, you value it with full benefit of hindsight. The benefit of hindsight tells us that the asset, as at the date of judgment, was zero.
Yes, but so I'm not really talking about whether the transaction's been impugned or not. It's the question of whether what might otherwise be said to be... this is a case where the restitution of the shares is not possible.
Indeed.
So you ask the question of compensation for loss caused.
Indeed.
By, on this hypothesis, the breach.
Yes.
And the question is whether it was said, well, at the time the shares were transferred away, they were worth 100. looking at it now, we know they're worth nothing.
Yes.
In answer to the question, therefore our loss is 100.
No. Well,
You say no,
That's-
because something has happened in the meantime, which is not the result of.
which is not the
The
result
breach.
of the breach of duty.
Yes.
And
So-
therefore you say no different to fluctuation in market value.
Exactly.
Right. So that you said, that's why you said we weren't in this territory. I thought we were. The actual question that we may be getting on to, which I don't think Lord Reed answers, is who bears the burden of showing the interruption of what might otherwise be said to be the chain of causation, or whether it's all down to the claimant to show
Well,
that, as it were,
to
the
talk about
loss he would otherwise
sorry.
have suffered is well, you know where I'm going.
Yeah, I do. But to talk about the chain of causation being broken suggests that in any sense, the diminution in the value of the shares is even arguably a result of the breach of duty. It isn't. What all these cases have told us is that the entitlement of the Setike Trust is that the trust is duly performed. If the trust had duly been performed, the shares would still be registered in the name of the company. It would be holding 891,000 shares, which are worthless. So it's the trustee, it's the joint receiver, the joint liquidators, who wish to argue for some hypothetical different world in which they would have sold the shares at some earlier date. Sorry.
I mean, I know you're on the law at the moment. We're distracting you with the facts. But I do find this transaction very, very strange. If we start off assuming that JJW Inc. had enormous net value, which is the hypothesis, I can't imagine on what basis that ceased to be the case. You can't have had consent of all the members because the company was a member and it didn't consent. So how was it possible for this vast amount of net asset value to be transferred out of the company?
Lord, the way in which the liquidators pleaded their claim means that that question wasn't answered and doesn't need to be answered. The transfer out in July 2017 is just a fact of history. The answer may be that they were nervous that if they joined JJW Inc. and alleged that the transfer out of its assets was damaging, they would be met by a reflective loss defence because they were shareholders in a company whose value was being reduced. I don't know, I'm speculating. But for whatever reason, JJW Inc. wasn't joined, and the transfer of assets out of it was not impugned as a breach of duty. The fact that that transfer out wasn't disclosed by the sheikh was pleaded as part of his supposed breaches, but there was no...
Was even, you mean under the latterly re-amended pleadings? Because, of course, they couldn't be re-amended till the fourth day of the trial, because before that, they didn't know they were talking about a transfer of assets.
Yeah.
But can you think of a basis on which it would have been proper?
Well, my lord, I have absolutely no idea what JJW Inc. would say in answer to that question. It could only be answered on the basis of evidential material to explain why it happened and the basis on which it happened. It is simply off the table with the respect. Can I try and crack on? So Ahmed, at tab 55, is factually not dissimilar to our case in the sense that it involves shares rather than cash, which fluctuate in value. Factually, what happened was that shortly before a bankruptcy order, a debtor transferred various shares to siblings, and between the date of the transfer and the date of the trial, the value of the shares went down. It was accepted that the transfers were void under the Insolvency Act, and the question was whether the siblings were liable to pay the value of the shares as at the date of the transfer, at which the trial judge said yes, and the Court of Appeal said no. Applying Target and AIB, the Court of Appeal said no. There is, as the judge said in Target, there may be a breach at the date of the transfer, but the function of equitable compensation is to put the Setike Trust in the position it would have been in if the trust had been performed. If the trust had been performed, the shares would still be there. If they have gone down in value as a result of whatever it is, market forces, a transfer of assets, if the shares as at the date of judgment would in any event have gone down or become valueless, then equitable compensation is calculated by reference to that fact, unless the trustee can prove that they would have sold at some earlier date. And one gets that in this judgment, if I can just try and deal with it as lightly as possible. So page 1211 is, you see 2/3 of the way down the page, issue 2, approach to the determination of liability. And the Court of Appeal is a little unkind to the trial judge, saying it's hard to follow the reasoning. Seems to have taken the view that the trustees did indeed have to establish loss caused by the breach, following Target and AIB, and that the loss had indeed been caused by the breach, and that apparently the breach occurred at the transfer date when the first appellant became a trustee, and that the loss was the diminution in the value of the shares from that date until the shares were returned. However, no explanation is given as to why she thought that a breach occurred or the losses suffered on that date, other than her view that the first appellant had held as a trustee from that date and owed a fiduciary duty to preserve the value of the asset. And then at paragraph 34, she says she couldn't agree with that approach. The word restitutionary, as used in the authorities, is used in the sense of restoring trust property actually lost as a result of the breach of trust. The trustees, in fact, have chosen to make a case for compensation based on breach of trust. The case is clearly established that compensatory relief, in addition to the restoration of trust property, is available where the claimant beneficiary can establish a loss to the estate caused by the trustee's breach of trust. Clearly a finding there about where the onus lies.
Sorry, can you just give me that?
Sorry, paragraph 34, 6 lines down, or 4, 5, 6 lines down. The case is clearly established that compensatory relief, in addition to the restoration of trust property, is available where the claimant beneficiary can establish a loss to the estate caused by the trustee's breach of trust. Over page, paragraph 35. Thus, as AIB and Target demonstrate, liability in equity is fault-based, and the relevant loss for which compensation is payable must be caused by the actions or omissions of the relevant trustee. As the appellants have now returned the shares out on the facts of that case, the only case remaining is one for equitable compensation. The decision of the House of Lords in Target Holdings, considered and upheld by the Supreme Court in AIB, represents the highest authority for the proposition that in order to recover equitable compensation, the trustee must show, again, onus of proof, actual loss caused by the breach. Sorry, yes. The trustee is the trustee in bankruptcy in that context, not the defaulting fiduciary. And she says, paragraph 38, the present case falls neatly within the principles established in AIB and Target Holdings. At 1222, paragraph 56, the fact that the breach occurred on that date does not predicate that the loss occurred on or will be calculated as at or as from that date.
Sorry, which paragraph?
I'm sorry, 56.
56. Yep.
56, page 1222. The fact that the breach occurred on that date doesn't predicate that the loss occurred on or will be calculated as at or as from that date. In Target, Lord Brown-Wilkinson made it clear that in cases of breach of trust, the remedy is restoration of the trust estate, and the relevant loss for which the compensation is payable must be the actual loss caused by the actions or omissions of the subject trustee. In other words, when determining loss, the court is required to look at the actual loss suffered by the trust estate. On the date of the bankruptcy order, the trustee in bankruptcy still had not been appointed, as such he couldn't have realised, and then she deals with the facts. And then 57, I accept the submission that in this case the loss occurred or flowed from the date at which the trustee in bankruptcy would have actually sold the shares. Para 57. And then at 61 is the conclusion over the page, 1223 at 61. In my judgment, the judge was wrong to find that the appellant's liability for loss flowed from the transfer date. It flows from the date, as we saw from 57, when the shares would actually have been sold. And the last authority in the thread, which you will have seen in the judgment, is Auden, Mackenzie and Patel. That is in the authorities bundle at tab 57. I am running out of time to deal with it, so can I just give you my propositions by reference to it and commend you to the sidelined passages. The reason that one dwells on it at all is that the trial judge in this case said that she considered that it cut across what the Court of Appeal said in Ahmed. The words cut across appear in paragraph 566 of the judgment below in this case. Our submission is in relation to Auden, Mackenzie and Patel, is first of all that the judge in this case was wrong to think it was saying anything different from the earlier authorities. Secondly, it is, with respect, a little anomalous to spend too much time considering Auden, Mackenzie and Patel, bearing in mind it wasn't a judgment at trial making any findings of liability. It was a judgment in which, in fact, the outcome, it was a judgment on a summary judgment application in which leave to defend was granted. So it's not exactly conclusive on anything that's discussed. Third point, it is even more anomalous to spend too much time considering it, bearing in mind it was decided about 10 months after Ahmed, but Ahmed wasn't cited. Fourth point, it does not, unlike Ahmed, it does not provide a useful analogy with the present case because it was concerned again with a payment of cash, not a transfer of shares, and there was no question of fluctuating value. The fifth point in the case is that, properly analysed, it was essentially exactly the opposite of our case, because the defence in that case, what had happened is that huge sums of money had been paid out to the directors, and the company then sought summary judgment, and the director said, oh, well, we could have paid it all to ourselves lawfully by way of dividend. So the argument that was trying to be run by way of a defence in Auden Mackenzie was inviting the court to take into account something that had not happened. A hypothetical, namely a lawful distribution by way of dividends. Our case is exactly the reverse. We are inviting the court to take into account something that did happen, namely the diminution in value of JJW Inc. So, as I say, it is surprising that the trial judge in our case considered it to be of assistance. But ultimately, we submit that, properly analysed, it does nothing more than follow Target and AIB, in the sense that it recognises that the equitable principle underlying equitable compensation is to put the trust estate into the position it would have been in if the fiduciary had performed its fiduciary obligations. If we apply that approach to the facts of this case, our argument is very simple. We say that, and I've probably already said it in the course of answering some questions, first, but for the assumed breach of duty by the Sheikh in effecting the transfer of the 891,000 shares, the company would have remained the registered owner of those shares as at the date of judgment. The value of the shares as at the date of judgment was 0. If the joint liquidators had wanted to persuade the court to adopt a different valuation date from the date of judgment, the onus was on them to prove that they, well, in fact, Ms. Caulfield, the sole liquidator at the time, would have realised the shares at an earlier date, before the transfer of July 2017. The question whether the liquidators could discharge that burden is the subject of ground 2D. I'm just dealing with grounds 2A, B and C at the moment. It is difficult to see, with respect, how the judge got where she did. If I could just point briefly to the sequence of the argument. If we turn up paragraph 549, subparagraph 9, so page 251 of the core bundle. Where the judge is setting out the principles, the legal principles, and at little Roman 9 on page 251, the amount of the award is measured by the objective value of the property lost, normally determined at the date when the account is taken, i.e. the date of trial, and using the benefit of hindsight and common sense. Correct. As we have seen, paragraph 574, and also we've already been to it, 5573, the judge held, we say again rightly, that as at the date of judgment, the shares were valued at 0. And yet...
She doesn't go quite that far, does she?
Well, she does, if you join together, if we look at 5573, which is at the top of page 255. July resolution pursuant to which all of the assets were transferred to JJW UK such that, as at the time of the transfer, JJW Inc. shares must have been worthless.
At that stage, it's the liquidator's case.
Well,
no, I think she is like
pieces of evidence. Is
yes,
what she says
exactly. This is not argument. This is simply identifying the evidential material upon which the liquidator is relying, it is a comment in a sense of fact that it was both the liquidator's case and it was, in our submissions, her finding at 5573 that the JJW Inc. shares must at that point have been worthless. It's said in slightly equivocal terms in 574, where she says, I bear in mind that July 27 transfer appears on the MBI response own evidence to have had the effect of denuding the 891,000 shares of all value. And I note that the MBI response have not sought to deduce any evidence to contradict that state of affairs. So the court was in the position, it was the liquidator's case that the shares were valueless, and the MBI respondents, includes my client, have produced no evidence to the contrary. So in our submission, it is the case that the judge was presented with no other alternative, and indeed we would do submit that the correct reading of paragraph 5573 is that she did make a finding that the shares were valueless.
I'm taking out of your course a bit, and you will say, I think, that this really doesn't matter. But I do puzzle over how the transfer of assets can have taken place without JJW Inc. getting anything in return. But if it was possible for that to happen, then I don't suppose the shares were worth very much before it happened. Because if it was possible to denude the company of all its assets in a legitimate way like that, then the shares probably weren't worth much beforehand.
That is a perfectly rational observation, my lord. I'm not sure. I can't, as I have said before, I think, I can't do anything other than work within the four walls of the judgment, which necessarily reflects the issues that the claimants chose to bring. So, how then did the judge get at paragraph 576, page 260, to saying, assessing the available evidence as at the date of this judgment, and
Sorry,
having...
Are you moving sequentially through the judgment? I know you...
Not quite. So I just want to show where she got to, and then go back to where I think she went adrift.
Okay, all right. Well,
so I just wanted to pick up that 576 is the conclusion.
Right. Okay.
Assessing the available evidence as at the date of this judgment, and having regard to having regard to hindsight, and the application of common sense, I consider that making an award of 67 million odd euros would provide appropriate equitable compensation for the misappropriation of the 891,000 shares. Now, on the face of it, that doesn't explain why she has chosen a valuation other than as at the date of judgment. And nowhere in the judgment does she explain why it is irrelevant that the diminution in value was not caused by the breach of fiduciary duty which has been found against the sheikh. There is simply a gap in the logic of the reasoning. The breach is the transfer. We are told by the authorities that equitable compensation is awarded to reflect the loss which was caused by the breach. The breach in this case did not cause the diminution in value. The transfer out did not cause the diminution in value. The March 2016 share transfer didn't cause the diminution in value. The diminution in value was caused by a transaction which was not itself a breach of duty by the sheikh, alleged or found. So, the judge in our submission has made a decision which is unprincipled and doesn't apply the correct case law, correct approach in the case law. The reason she, with respect, and I don't want to sound unkind or harsh, this is a monstrous case. We just only have to look at the hearing dates on page 117, running from February 21 to October 2022, to see what a beast procedurally it was. The list of issues, as I say, it's 39 main headings and many of them multiply subdivided. There were huge issues of fact, endless complications of law. It is possible that this particular point, which we're now focusing on, as sometimes happens in appeals, just slipped between the cracks in the judgment, because one looks back at para 558 and following. So, but if your lordships could just read 558 to yourself, because there's a hint here that the liquidators are going to try making some sort of case that the sheikh is responsible because of the use of the word dissipated, 4 lines from the end.
I mean, what I understood the judge to have done is to say, on the figures, when the breach occurred, the shares had a high value.
Yeah.
So it seems. Looking at it now, the shares have no value.
Yep.
That, everybody seems to agree, is the effect of the 2017 transfer.
Yeah.
And I suspect you may have shared my Lord's concern about how that had occurred and whether that was, in a sense, only permissible as a consequence of a 100% share ownership being vested effectively in the same party. But I thought the way that the judge had essentially got there is if you go back to 549 at Little Roman 11, there's a reference to the Libertarian. Where the claimant provides evidence of loss flowing from the relevant breach of duty, the onus lies on the defaulting fiduciary to disprove the apparent causal connection between the breach of duty and the loss apparently flowing therefrom. Is one explanation of this. The judge has basically said, look, on the face of it, you've got a breach of duty, the company goes from having an asset worth a lot. By the time of the trial, it's seen the asset is worth not very much, it hasn't been restored. There's been a loss in value. The apparent causal connection, the fact the company just simply doesn't have those shares worth X at the date of the trial, is the fact that they were transferred away in breach of duty. And so the onus is on the defaulting fiduciary to explain why it is, to quote, disprove the apparent causal connection between the breach of duty and the loss.
Okay.
It goes back to my comment that Lord Reed made in AIB and Redder.
Well, can I answer that?
About something that disrupts the otherwise apparent chain of causation. And if that's right, nobody explained why it had become, why, if you like, why it was inevitable, or why it would have happened in any event that the shares would have been denuded in value even if retained by the liquidators.
My Lord, could I answer that with, as briefly as I can with 2 points? One is, that is not anywhere articulated in the judgment as the reason why the judge values the supposed loss anything other than as at the date of judgment. And the second is premised on what we submit is a false premise, namely that there is somehow an apparent causal connection between the breach of duty and the loss. The breach of duty is a transfer in March 2016. There is no apparent causal connection between that. If there is, it is wholly unevidenced, unexplained, and doesn't form part of the judgment. So with respect, there just isn't the material in this judgment to say that that is the basis upon which the judge made a decision.
I mean, it might be said against you, well, quite follow, there's a dearth of evidence about all this, but you were the ones with the knowledge. The liquidator couldn't even have been expected to investigate before the fourth day of the trial because it hadn't been suggested. You had the opportunity to bring before the court materials that would remove the fog and explain how the transfer of assets happened. And you didn't.
Any defendant will adduce evidence to deal with the pleaded case. JJW Inc. Is not a party to the proceedings. Whether it was the fourth day of the trial or earlier, the evidence was, the position put to the court was that there was this asset transfer. And our submission is quite simply that there is no apparent causal connection between the breach found and the diminution in value. What happened, what I was going to get on to, is if one looks at paragraph 559...
So just to be clear, I mean, does your argument actually depend upon the fact that there is no, as you put it, nobody has impugned the 2017 transaction? Because otherwise, it's a charter for sort of fiduciary to breach his duty, take an asset out of the company, and just make sure he strips it of value, so that by the time he's sued, he can say, no loss.
Well, it rather depends who is being sued for what. I mean, again, one comes back, one doesn't have to strain to the law to produce an outcome on the facts of this case in relation to the claim that has been brought. In other cases, there may, if there's a case to be made in conspiracy, deceit, causing loss by unlawful means, knowing dishonest assistance or knowing receipt, different fact situations can produce remedies.
But you see, the position is that if we're on the hypothesis that a fiduciary has defaulted and removed an asset from the company and is under a continuing duty to put it back.
Yes, indeed.
And he continues not to put it back.
Yes.
So if, for example, let's take a different situation which in fact some cases have dealt with, which is where the asset goes up in value in the meantime and then falls in value and is restored. Can the company say, look, if you'd have fulfilled your duty, performed the trust, which is where you say we get into this, you have to be put back into position as if the trust had been performed, can it claim the interim
absolutely.
increase?
Yeah, that's one of the points made in Canson.
Right.
There was a Canadian-Indian case, actually, where an Indian community was displaced, and the foreseeable loss from that, it was a breach of a public law duty, but it was treated as being an equitable claim. The foreseeable loss was the agricultural value of the land. It turned out, I can't remember what it was, whether they found oil under it or something. Wholly unforeseeable, and the compensation was awarded for 10 million, not 10,000, because, as it turned out, with the benefit of hindsight, if the asset had been restored as at the date of trial, £10 million worth of asset would have been restored. So absolutely, it works both ways. If the asset goes up in value, the trustee can't say, well, that's a bit rum, because I didn't realise that was going to happen. And if it goes down in value, the beneficiary can't say, oh, well, I need to be compensated for something that the trustee didn't cause.
Well, exactly, but that presupposes, therefore, that the diminution in value that occurs whilst the asset is out of the hands of the beneficiary is not caused by the fiduciary.
Well, that was no part of the trial agenda.
And
so
you say the burden of proving that this all falls on the claimant.
Well, yes, I'd say that. But irrespective of where the burden of proof lies, the court has got to make a finding of a causal connection, which it hasn't.
So what did Mr. Justice Ribeiro mean in I can't remember the name of the case now, in Libertarian?
My Lord, can I just hold on that and perhaps give an answer when I'm replying, because otherwise I'm simply going to run out of time to deal with the issues that I want to do. Just in order to try and see why the judge, with respect, we suspect, just got distracted in dealing with this issue. If you look at 558 and then you look at what she deals with in 559, you'll see she says that the MBI respondents contend that the correct approach to equitable compensation is reparative, and the compensatory focus requires an analysis of what loss has actually been caused, as otherwise the liquidators will obtain a windfall which will not correspond to any profit made by the trustee, such that it would be penal. Accordingly, they invite the court to consider causation by reference to various counterfactuals and an alleged intervening act. And then the counterfactuals are listed, none of which is in fact the point that we are now debating. The counterfactuals to which our attention was drawn was not the fact, because it wasn't a counterfactual, it was a fact that the diminution in value had occurred and was not the result of the breach that she was being asked to find. So what she then dealt with in rejecting the argument that the case law required her to take into account counterfactuals were different points. She seems not anywhere between paragraphs 559 and where she ends up at 576 to address squarely the point that we're making. And that really, in a sense, is as much as I can usefully say. If she took a decision of principle that the loss should be calculated at the date of the transfer, she was wrong by reference to Ahmed, which follows Target and AIG. If she took what was essentially a discretionary decision, choosing a date for valuation, it is wholly unprincipled and unexplained.
I mean, to go on to a point you're going to come to, were one to construe the judgment as meaning that the judge thought that the liquidator would have realised the shares before the loss of value, then that would be a perfectly intelligible basis for a finding.
Yes. Yes. Which is 2D. That's grounds 2D.
Yes.
Very shortly, we submit that the judge made two errors of law and evidential errors which subvert the finding. The holding was actually obiter. She has rejected what she describes as a counterfactual, namely the question whether it's relevant whether the liquidators would have sold. She actually rejects that as a relevant consideration between paragraphs 559 and 566. But then she says this obiter in 567, even if I'm wrong, and Ahmed is to be seen as establishing a different rule, that's not our case, but anyway, that's what the judgment says. In the case of share transfers in a bankruptcy or insolvency situation, Ahmed was, of course, decided on its own facts. In other words, on the basis of the findings of fact made by the judge as to what would have happened in the circumstances of that case. Insofar as the MBI respondents seek to advance the case based on the counterfactual and/or an intervening act breaking the chain of causation, the onus lies on them to satisfy the court on balance that their case is correct. That's the error of law. The onus is on the Setike Trust here, the joint liquidators, to establish that the court should choose a valuation date other than the date of judgment. So the onus is on the liquidators to show that they would have sold the shares. So that's the first error of law. The second error of law is that in then deciding whether she was satisfied that the liquidators would or would not have sold, she recites, I don't have time, but paragraph 568 recites all the difficulties that the liquidators were facing. And then at 569, she draws conclusions. I declined to draw the inference I was invited to draw by the MBI respondents in relation to the absence of Mrs. Caulfield. It was said that an adverse inference should be drawn as to what she would have said about an intention to sell, because she hadn't been called at all. Whilst it may well be the case on the available evidence that Mr. McKinnon would have regarded the realisation of JJW Inc. shares to be premature, not least because he was involved in the Sheikh's application to terminate the liquidation, I do not consider that the contemporaneous evidence supports the inference that I am invited to draw in relation to Mrs. Caulfield. Miss Caulfield. Now, the inference there is not the question of whether she would have sold, but whether an adverse inference should be drawn from her absence as a witness. But then the finding on the evidence is this. It seems to me on the evidence that she was doing what she could to progress the litigation, true but irrelevant because there is no evidence she tried to sell the shares, in the face of stonewalling from the sheikh, that the steps she took to progress the liquidation were reasonable, fine, true but irrelevant, and insofar as it is necessary for me to do so, I find that had she been provided with accurate information, she would have taken appropriate steps, to take control of the 891,000 shares and to realise them for the benefit of the creditors. So the second error of law is that she asked the question as to whether the shares would have been sold on the basis of a false hypothesis. The relevant question for the court is what would have happened but for the breach of duty. The breach of duty was the transfer in March 2016. No other facts can be changed by the judge in postulating what would have happened. The judge was not entitled to assume that the sheikh didn't stonewall. The judge was not entitled to assume that the sheikh would have provided more full information, because that is simply a hypothetical world that didn't exist. The only question for the court was what would have happened but for the breach. So the question was, would the liquidators have sold? If one of the reasons they didn't sell was they didn't have perfect information, the judge has to take the decision as to whether they would have sold absent perfect information. So we do say that there were those two errors of law. There was also, frankly, a total absence of any evidence of any intention to sell. There is literally one document which is mentioned in the judgment, it was mentioned at trial, and it is mentioned in my land friend skeleton, which is a letter. We won't go to it, but it's in the supplemental bundle at tab 12, page 62. It's a letter from the liquidator to the sheikh saying, we have no funds to proceed, please send $400,000 or I will have to take steps to realise assets. That is the evidence that the liquidators would have sold the shares. Properly understood, it is evidence they wouldn't, because the sheikh did not provide $400,000 and no steps were taken to try selling the shares. So the fact that the threat was made and nothing was done is positively evidence of an absence of an intention to sell. And the other point, there is a number of evidential points that the judge simply didn't take into consideration, one of which is that the 129,000 shares have been sitting with the company throughout and no attempt was made to sell those.
I have to say, I struggle with the whole relevance of this wanting to sell bit. If I own shares in a company which are very valuable, I may not want to sell them at all.
No.
If my trustee in breach of duty transfers them to another, and I just haven't got them back at the date of trial, why does it matter whether I would have sold them or wouldn't have sold them? I have lost, on that basis, shares which, so far as everybody knows, are still worth what they were worth when they were taken from me, namely a very high figure, if I had wished to sell, which I never did. My loss in that very simple case, where the shares have just gone, but there's no evidence that anything's been done so as to diminish.
Oh, I see. Yes. So the shares are still valuable at trial.
So it's
on this side. Okay.
So on that basis, whether I would have sold them or whether I wouldn't have done, doesn't matter.
I agree.
I just might have not had the opportunity, which focuses attention again on the reason for what is said to be the diminution in value, what was agreed to be the diminution in value in the meantime.
No,
if it's market, then I understand you say, well, if the evidence was you would have held onto the shares and just watched them plummet, or some catastrophic market event would have occurred in any event, that can't be laid at the door of the delinquent fiduciary. Understand that. So that's why the focus is all on the intervening event.
Well, it is precisely no focus was applied to the intervening event.
No, in a normal case,
I see. Sorry.
you have to focus on why, what intervening event, what type of intervening event has occurred.
Yes.
So as to
Okay. But
say that the loss is zero because it would have been suffered by you in any event and isn't caused by the delinquent fiduciary.
Yeah. But if there is no case put that the loss, if there is no case put that the diminution in value was caused by the breach of duty, and there is no finding in the judgment that it was caused by the breach of duty, one is left with a position where the trustee, the joint liquidators, have a hard choice between asking for valuation as at the date of trial, when the asset might otherwise have been returned in specie, or they have to satisfy the court that some earlier valuation date is appropriate. And they have to satisfy the court that an early valuation date is appropriate because they would have sold the shares at an earlier date. Otherwise, choosing an earlier date is simply a pig in a poke. It is just sort of plucking a number. There's got to be a principled approach to choosing the valuation date, and the only principled approach has got to be that you are essentially, we put it in the skeleton in this way, and there's reference to it, I think, in Target, that you're, in a sense, you're valuing a loss of an opportunity. You're not really valuing the shares. You're valuing the loss of the opportunity to sell the shares at a date before they dropped in value. Just to try and wrap up, on ground two errors of law, misunderstanding of the one letter that was relied on, and a failure to take into account the fact that there was no witness evidence from any liquidator, Mr. McKinnon, Ms. Caulfield, that the shares would have been sold. So there was simply an absence of evidence, a complete absence of evidence to support the finding that the liquidators would have sold. And the one piece of evidence, as I say, on which the judge relied in our submission, properly understood, positively indicates that the liquidators would not have sold, and didn't, despite their threat. There is, in our submission, appropriate material for the court to reach the view that the right valuation date was, in fact, the date of judgment, and that there was no principled basis for choosing any earlier valuation date. Ground 2E, I hope to deal with extremely briefly, but it is highly significant. This argument, the ground 2E, is 67 million right, even if 67 million euros, is that the right number, even if a date pre-July 2017 asset transfer is the appropriate valuation date. And there are two questions. One is, why is the valuation conducted by reference to December 2016? The answer seems to be not because on any principled basis the judge took the view that that is when the shares would have been sold, but simply because there were accounts available. The evidential tail appears to have wagged the principled dog, because the judge simply took the December 2016 JJW Inc. accounts as the only available evidence, and she describes it as being the best available evidence as to the value of the shares in paragraph 572 of the judgment. The fact that evidence is available does not mean that that is the right date to choose as being the putative date on which the shares would have been sold.
But is there any reason to believe that the value of the shares changed between the date of their transfer and the events in the middle of 2017?
I'm not aware of any, no. Second question under 2E is 67 million euros the right number? As to which we make, I think, 4 very short, very simple points. The first is, and this was pointed out in oral argument but not addressed in the judgment, the first is that there simply was no evidence that the shares had any market at all. Who buys a small minority holding outside the terms of any sort of flotation? What market was there? There was no evidence that they were marketable. It's axiomatic that shares only have value if somebody's prepared to buy them. Second point, it was in our submission wrong in principle.
Oh, sorry, you say it's axiomatic, if only somebody's prepared to buy them. I mean, one other possibility is that if somebody's not prepared to buy them, the company's wound up and the assets, the surplus is distributed to the shareholders.
Yep, but that's not the basis upon which, this wasn't done on a breakup valuation, on a sort of fire sale valuation. This is done on the basis of attributing, and this is my second point actually, attributing a pro rata valuation to a minority shareholding. It is, again, in our submission, a general principle of company law, described as such in Masso and Shander, which is cited in our case, in our skeleton, that when valuing shares, you value what the person is selling. If the person is selling a minority shareholding in a private company, then a minority discount is to be applied. The third point, which was made at trial, although I notice it's not in fact in our skeleton, for which I apologise, but the third point that was made at trial is that the company's articles of association included a provision conferring on the directors a power to refuse registration. That's quoted, if you want to see it, it's quoted in paragraph 37. We don't have the articles in their entirety, but Article 4.2 of the articles is quoted in paragraph 37 of Mr. Fay's report, the expert report, which is in the supplemental bundle, tab 17, page 94. That, again, in our submission, is a relevant item of information that would have diminished the value and it contributed to the finding that it was wrong. Contributed to the argument we submit.
So
it was wrong to apply.
Why did the Sheikh give the estimated to realise value of the shares as $134 million in the statement of affairs?
I can't answer that question, but all I can say,
if all these submissions are right, then he should have just said zero.
My lord, the judge was asked to take into account the statement of affairs as the liquidators, I think, preferred item of evidence for valuation, and she refused to do so because, in her view, it was prepared on the basis of error, and one sees that in the so that's paragraph 558 is where she says she rejects the statement of affairs as an appropriate, as a reliable indicator of value, and she says that it's based on an error, and we apprehend, although she doesn't say so in terms, that that's a reference back to paragraphs 72 and 83 of the judgment. I don't have time to go to it.
Sorry, 558?
558, yes. Is where she discusses whether to use the statement of affairs as the best indicator of value.
So, and you say it's a reference back to where?
The error,
yes,
referred to there appears, I think, I mean, it doesn't say so, but our best guess is that it's a reference back to paragraphs 72 and 83. The fourth point on whether or not this was the right number, we have made in our skeleton argument and that is a peculiarity in this case. The short point is this, that in the context of one of the claims that was dismissed, the claim that in 2009 the three entities that we looked at right at the very beginning of the case, the Ajwa Group, Jadwal and JJW Guernsey, the argument that those three entities were wrongly transferred out was based partly on the 2008 accounts of MBI Holdings, of the company, to be clear. And the interpretation of those accounts is given in paragraph 331 of the judgment. Surprising though it may seem, the same wording appears in the 2006 accounts of JJW Inc. and is dealt with in paragraph 35 of the judgment. Could I simply, I don't have time to explore it, but could I just invite your lordships to read carefully paragraph 331 and then paragraph 35, and you will see that the conclusion is that the judge was saying that those accounts included financial information on companies that were not in fact subsidiaries of the company in one case and JJW Inc. in the other. So there is an internal inconsistency between paragraph 35 of the judgment, where the judge makes that finding, and paragraph 576, where the judge treats those accounts as the best available evidence of the value of the company. Ground 3 is the question of the unpaid vendors lien. I am nearly out of time. Can I just give you some headline points in relation to it, and then let my learned friend, Mr. Fenimore, have his time. The issue under ground 3 is whether or not the judge was right in saying that there was no unpaid vendors lien. You remember that this arises because if we go back to the organogram, the purple transfers back in 2009 from JJAB and JJW Guernsey required consideration to be paid of somewhere around 89 million, which was never paid. The argument was that they were entitled to an unpaid vendors lien. There are, perhaps surprisingly, I think 6 issues under this heading. Very quickly, the first argument that my learned friend wishes to raise is that it wasn't open to us to contend that there was an unpaid vendors lien. Our answer to that is it's too late for my learned friend to run that argument. The issue is debated at trial. The judgment contains a ruling on it, and it is too late in this court to complain that a trial judge dealt with an issue when the complaint was not made and ruled on by the trial judge. The second issue my learned friend now wishes to raise is that the question whether there was or wasn't an unpaid vendors lien is a question of foreign law, BVI law. And he says no evidence of BVI law was adduced, and therefore there was no material upon which the judge could proceed. That again is a point that wasn't taken at trial. My learned friend has to persuade you to let him take it now. Assuming he does persuade you, the fact remains that the case was argued and decided by the judge, paragraph 485, expressly on the basis that BVI law was the same as English law on this point. So since neither party pleaded that there was any difference between BVI law and English law, there is nothing in that line of argument. The third question is whether there was an unpaid vendor's lien over the shares transferred by JJAB and JW Guernsey. So far as that is concerned, our submissions are substantially based on the case of Barclays Bank and Estates and Commercial, which is in the Authorities Bundle at tab 25. And we submit that the propositions are very simply that an unpaid vendor's lien arises by operation of law. It arises as soon as a binding contract is entered into. Its effect is to give the vendor a lien on the property for the purchase money, and it's discharged on completion to the extent that consideration is paid. And finally, it can be excluded by contract if there is an express provision or if there is a clear and manifest inference that it was the party's intention to exclude it. The judge decided that there was an express contractual exclusion because the transfer agreements, the share transfer agreements, which are in the supplemental bundle at tabs 3 and 4, include the words free from encumbrance. And our answer, as you will have seen in our skeleton, is that that was intended and could only sensibly have meant that the shares are being transferred free from any third-party encumbrance, not that it was intended to exclude the unpaid vendor's lien. Indeed, one of the authorities we've included is Winter and Lord Anson, in which those very words, free from encumbrance, were included in the conveyance, and yet the unpaid vendor's lien was held to exist. In our submission, that is not a good point. There was no exclusion by inference. The judge thought that the unpaid vendor's lien must have been intended to be excluded by necessary implication or by the common intention of the parties because of the intended onward sale of the shares in JJW Inc. But in our submission, that is a misunderstanding with respect, because the onward sale would not have been prevented by the unpaid vendor's lien applying to the proceeds of sale in the hands of the company if and when it sold the shares onward. And the case, if by any chance you have the energy to read the Barclays and Estates Commercial case, there's a consideration in detail of a case called Kettlewell and Watson, which deals with essentially exactly this kind of point and puts paid to Milan and Fran's argument.
But this is odd because it goes back to the point we made first thing. I didn't envisage that the actual shares were going to be sold on as part of the IPO. I mean,
the shares owned by the company in JJW Inc., as I understand, were intended to be sold on. That seems to be the basis upon which the judgment proceeded on this point. And that's, as I say, why I said just after the short adjournment that our researchers do suggest that JJW Inc. was the IPO vehicle. Very briefly, I must draw things to an end. The liquidators suggest that there has been waiver. In our submission, none of the material upon which they seek to rely contains anything remotely approaching an unequivocal statement of an intention not to rely on any unpaid vendor's lien, and none of the statements on which the liquidators rely is in fact a statement made by or on behalf of JJAB or JJW Guernsey. They are all statements made either by the Sheikh in his personal capacity or on behalf of the company or on behalf of JJW Inc. None of them are statements that can bind JJW Guernsey or JJAB. Fifth point, the liquidators say that my client comes to court with unclean hands. Our answer is that that is an irrelevant argument to be running. The question of unclean hands arises where a party comes to court seeking equitable relief by invoking the court's equitable jurisdiction. My client is doing no such thing. He is the defendant in proceedings, And in defending the proceedings, he is not invoking the court's equitable jurisdiction, he is simply pointing out a fact, namely, that the loss which the liquidators claim the company suffered is non-existent, because the value of the shares in the company's hands was always subject to the unpaid vendor's lien. And that, in a sense, answers my learned friend's sixth and final point, which is, he says that even if there is an unpaid vendor's lien, it would only be available to JJW Guernsey as the fifth respondent in these proceedings in relation to the shares it sold, the 567,556 shares which it sold, and not in relation to the proceeds of sale of the 324,000 shares transferred by JJAB. And that, with respect, simply displays a misunderstanding of the point. My client is not seeking to enforce the unpaid vendor's lien. He is simply pointing out that the value of the 891,000 shares in the company's hands is nil in real financial terms, because having never paid for the shares were always subject to the lien, and if the company ever sold them, the proceeds of sale, the lien would be overreached and would apply to the proceeds of sale in the company's hands, and for those reasons, the supposed loss which the company claims to have suffered is zero. Can I just check? I know I've overrun by some minutes. Can I just check if there's anything else I need to say now? I'm very grateful, and I apologise to my learned friend for having bitten into his time.
Thank you very much. Mr. Fenmore.
My lords, I hopefully can be very brief. JJW Guernsey is, of course, the Guernsey company which was the recipient of the 891k shares and was held liable to pay equitable compensation as a knowing recipient in the same sum as the sheikh. As we've heard, JJW Guernsey received the shares on the 8th of March 2016 when it was entered on the JJW Inc. register as the owner of the shares, and I'll come on to that in a moment. It then transferred the shares to MBI International Holdings on the 23rd of June 2017, around a month before those assets were again transferred to JJW UK in the restructuring that it's been said made the shares worthless. JJW Guernsey was originally represented by the same legal team as the sheikh, and so the original defence of the claim was filed on behalf of JJW Guernsey, as well as the sheikh and Issa Al Jaber and JJW UK, that did defend the proceedings originally. It was then placed into compulsory liquidation by the Guernsey Royal Court on the 31st of July 2020.
And that was a creditor's liquidation.
And so it did not participate at the trial, it didn't have the funds to do so. Its liquidators then instructed a separate legal team to attend the consequentials hearing, at which permission to appeal was given. So the fact that JJW Guernsey is in liquidation affects its position on this appeal and the reason why it's participating in these proceedings. That once JJW Guernsey's assets have been realised, then the Guernsey equivalent of the proof of debts process will take place. And in Guernsey, that involves the appointment of a separate person, a commissioner, so separate to the liquidators, who will examine the creditor's claims. And if there's any dispute, that will be referred to the Guernsey Royal Court. So JJW Guernsey's interest in these proceedings and in this appeal is ascertaining whether it is indebted to the company, and if so, in what sum. And the purpose of its appeal is to ensure that if the sheikh's appeal is successful, then the court's judgment and order reflects the appropriate consequences for JJW Guernsey too, so that this assists in clarifying the position in the Guernsey liquidation and in that equivalent proof of debts procedure I've referred to. So that's why it is here and why it is participating. You'll have seen that JJW Guernsey pursues the second and third grounds of appeal that have been raised by the Sheikh, and adopts his submissions on those grounds. The reason that JJW Guernsey does not adopt ground 1 is because that ground does not affect JJW Guernsey's liability. The Sheikh is not appealing, as we've heard, the court's finding that legal title to the 891k shares was transferred to JJW Guernsey as a result of JJW Guernsey being entered in JJW Inc.'s Register of Members on the 8th of March 2016. That is a consequence of the court's finding of the position as a matter of BVI law, on which it says the experts were agreed, which is recorded at paragraph 436 of the judgment that you've been to. And it's reflected in the court's finding that JJW Guernsey was legal owner of the shares, notwithstanding that the transfer was void. So it was never argued, presumably because of the position as a matter of BVI law, that the Register of Members is not the source of or determinative of legal title, rather than potentially merely being evidence of what legal title might be. And so because the transfer was void, the Register of Members in fact inaccurately reflected the legal position. That wasn't ever argued, and that doesn't appear to be the position as a matter of BVI law. So the Sheikh's appeal on ground 1 is therefore solely about his personal liability, because given that the court found that legal title had passed, and given that it also found that the transfer to JJW Guernsey took place after the company was put into liquidation, JJW Guernsey can't escape the consequence that it knowingly received the shares subject to the company's beneficial ownership. So whilst legal title is said to have passed to JJW Guernsey, on any view, even if the Sheikh is correct as to his personal liability and as to the breach of fiduciary duty that's been discussed in ground 1, the beneficial interest must have remained with the company.
I'm not sure I follow this. I mean, you were, what was the basis of you being held, your company being held liable?
The basis of it being held liable was that it was the legal owner of the shares, but it was a knowing recipient.
Right. But the first requirement of a knowing recipient is presumably there was a prior breach of fiduciary duty.
Well, I think you've got to be very careful about what specifically the breach of fiduciary duty is, because the reason that that is usually said to be an ingredient of a knowing receipt claim is because it is the breach of fiduciary duty that prevents the beneficial interest passing from the trust fund or from the beneficiaries of the trust fund to the recipient. It's that breach of fiduciary that prevents effectively the overreaching and means that the beneficial interest remains in the trust fund. Now, on any view here, even if the Sheikh is correct about breach of fiduciary duty, there has been a misapplication of assets in the sense that legal title to those assets have transferred in circumstances where post-liquidation the assets were not permitted or it was void to transfer them to JJW Guernsey.
Well, wait a minute. The legal title to the assets was vested in your company.
Indeed.
And it would seem, you can't doubt that because the entry is on the register.
No, indeed. And so the question is then, what happened to the beneficial interest?
Right.
Did it also pass to the company?
Well,
I'm not sure the answer to that is obvious. I mean, I can't quite see the register was capable of being rectified, but it's not immediately obvious to me that you achieved a separation between the legal interest and the beneficial interest.
Can we have a quick look at what the judge says at 518? That's all about legal title confirmed by registration on JJW Guernsey, as I pointed out earlier. And the judge says that it failed to restore the the shares,
Yes.
but instead transferred them to MBI International Holdings. But the basis for finding of liability is in 517, isn't it? Which is that JJW Guernsey, sharing the Sheikh's state of mind, was aware of the relevant breach of fiduciary duty by the Sheikh, together with the feature of the transaction I found made it dishonest. So that's why it's knowing receipt.
I mean, in one sense, perhaps Mr. Fenimore, we shouldn't worry ourselves too much because this is not a ground of appeal.
I was just slightly mystified as to why you're completely agnostic about ground one. Because if the Sheikh succeeds on ground one, I'm struggling at the moment to understand why you were held liable. Your company was held liable.
Well, if that is indeed going to be the finding of the court,
But you seem to think it's legit.
well, the reason I identify it is simply because it has been found that the transfer to JJW Guernsey took place post liquidation, and therefore was void.
Okay.
That simply explains the position in respect of ground one. If the court disagrees with that and considers that the Sheikh being correct on ground one means that beneficial title also passed to JJW Guernsey, or even that somehow legal title didn't pass to JJW Guernsey, so that it hasn't received anything, then I would invite the court to make a consistent finding in respect of the appropriate orders to be made against JJW.
And Mr. Curl might have something to say about that in circumstances where there is no ground of appeal.
He made it.
Yeah.
But that is the position in respect
Yes.
of ground one anyway, and why that's not being pursued. In respect of grounds 2 and 3, I say there's a difference, and those grounds apply to the quantum of the equitable compensation due to the company. And the straightforward point is that if the Sheikh succeeds in reducing or eliminating the compensation due under either of those grounds, the same consequence should apply to JJW Guernsey, which is paying equitable compensation in the same sum as the Sheikh. So following those points through, on ground 2, if the Sheikh is correct about the principles which apply to the quantification of equitable compensation, then those same principles will apply to JJW Guernsey. And if the Sheikh is correct to say that the measure of equitable compensation is instead the loss that has actually been caused to the company by the misappropriation, then that measure of compensation must also apply to JJW Guernsey. And I would just draw out one point, which is that it is important to remember that the 829k shares which were transferred to JJW Guernsey was not the company's only shareholding in JJW Inc. So the court does not have to sort of look into a crystal ball to consider what would have happened to the 829k shares had they not been transferred to JJW Guernsey, because it can just look at what happened in respect of the rest of the shareholding which was never transferred. And that is that those shares were not realised and have become worthless.
I'm not sure I'd picked this up in the judgment. How much did you get for the shares when you sold them on?
There's no record of any consideration being provided for the transfer of the shares onwards.
Why did your company just give them away?
There's no evidence of that. As in, there's no evidence of the rationale behind that transfer. I mean, it was a month before the what's been described as the 2017 transfer. So what one might conjecture as to its relationship to that, but the simple fact is there's no evidence as to why any of that happened. So that is ground 2. The Sheikh is correct in respect of ground 2. The same principles apply across to JJW Guernsey. Ground 3 is much the same. If the Sheikh is correct to say that the 891k shares were always subject to an unpaid vendor's lien, then it's also correct to say that the company has suffered no recoverable loss in respect of the transfer of the shares, and that must have an identical consequence for JJW Guernsey in respect of its liability for receipt of the shares. So again, the Sheikh submissions in respect of ground 3 are adopted because the principle applies to the quantification will be identical as against JJW Guernsey as it is the Sheikh. And that's, you may be pleased to hear, is all I was intending on saying. If you have any questions, I'd obviously be very much obliged to assist.
And I think you've admirably made up some time. So unless there are any questions, thank you very much, Mr. Fenimore. Over to you, Mr. Carl.
Thank you, my lords. I propose to structure my submissions in the same way as my learned friend Mr. Crowe, namely draw out some facts and then deal with the grounds in turn. I'll aim to get through the facts that I want to draw out before the court rises today. Should like to emphasise at the very outset on the facts, my lord, that this case is about the premeditated, dishonest misappropriation of the company's assets by its de jure director. There's no appeal from the very serious findings of fact that I've just summarised in a sentence there. The 891,000 shares went to JJW Guernsey on the 8th of March 2016. They then went on to MBI International Holdings on the 23rd of June 2017.
Well, can I be clear?
Yes.
Legal title only, I think. Is that right?
Yes, subject to what I'm just about to say, my lord. On the 8th of March 2016, legal title went. We, by which I mean the company, retained the proprietary base necessary in order to make out a knowing receipt claim as against JJW Guernsey.
Why?
Because it was done in breach of fiduciary duty.
So I see. So no, I follow that, but then so we're back to the question of breach of fiduciary duty.
Yes, in answer to my Lord Justice Arnold's question, yes, that is what happened on the 8th of March 2016, according to conventional principles, I would submit.
Or indeed, the statute says that a transfer of assets after liquidation is void.
Well, yes, that's right.
Unless the liquidator has instituted it.
That's right. But at trial, and I would wish to place a bit of emphasis on this, at trial, the Sheikh went in hard on the proposition that the registration of the shares in the name of JJW Guernsey gave rise to a very strong presumption that a beneficial title followed that legal title, and his expert was cross-examined on this and was pretty bullish on the point. So they're now trying to do complete opposite on this appeal, which is to say that the transaction didn't actually happen in some sense. So I just want the court to be very clear about how different.
There's two separate questions. One is the 29th of February transfer, as to which there's a finding that was void and neither side challenges that. Then there's the 8th March registration, as to which at the moment it seems to me to be common ground that passed legal title but not beneficial title.
Yes.
I can't see how that can be common ground. In the sense that you were explaining a moment ago that it depended on the proposition that there'd been a breach of fiduciary duty. Well, that's denied.
Yes, I suppose if the Sheikh is successful in showing that there's no breach of fiduciary duty, then the implications of that would be somewhat different. But I'm submitting to your lordship that there was a breach.
No, I follow that.
Duty.
I mean, just pursuing the other possibility for a moment. Supposing there were no breach of fiduciary duty, the shares are registered in the name of JJW Guernsey in the books of JJW Inc. You could have that rectified, but it doesn't immediately seem obvious that there wouldn't have been a passing of beneficial title.
Well, yes, I misspoke on that. I don't think that is common ground.
Sorry, it may not be common ground, but unless I've misunderstood the law, even in BVI as well as the UK, once a company goes into liquidation, the only basis on which its assets can validly be transferred is by a liquidator.
Yes.
And any disposition of the assets is void.
Yes. Save that a director is authorised in the manner that the liquidator could authorise it.
But nobody's suggesting that the Sheikh was authorised.
No, he certainly wasn't. No.
I mean, that's Mr. Crow's point.
Yes, precisely. Yes. And I'll come on to what we say about that.
On your case, how does JJW Guernsey get legal title?
Because it's registered in the books of JJW Inc.
So
I'm not sure that at the end of the day this is going to matter to us, but I think it's common ground that registration means that JJW Guernsey got legal title to the shares.
Yes.
A moment ago, you were attributing the idea that the company had retained beneficial title to the shares to a breach of fiduciary duty, and that obviously is what we're going to have to worry about. Insofar as there is an idea that regardless of breach of fiduciary duty, the company kept the beneficial interest, that isn't immediately so obvious to me, but it really
My Lord,
probably doesn't matter anyway.
That doesn't matter.
No.
Can we just leave that to one side for the time being? Because if there wasn't a breach of fiduciary duty, then I suspect we won't need to get into that, because the absence of a breach of fiduciary duty will be sufficient.
if you say there was a breach of fiduciary duty, which you do, and you say you retained beneficial title as a consequence of that breach of fiduciary duty, presumably you still have beneficial interest.
My Lord, that's the next thing that I was going to say. So perhaps if I could just move on with the next point I was going to make. The shares went to JJW Guernsey on the 8th of March 2016. JJW Guernsey then transferred them on to MBI International Holdings on the 23rd of June 2017. We know nothing about that transaction apart from the bare facts that I just summarised in a sentence there. It might have been for value, for all we know, and for all the evidence shows. MBI International Holdings, however improbable it might seem, might, for all we know, and for all the evidence shows, might have been a bona fide purchaser for value without notice from JJW Guernsey. And my Lord Justice Snowden, I think in exchange with Mr. Fenimore, you asked Mr. Fenimore what JJW Guernsey, his client, received, and when Mr. Fenimore indicated there appeared to be nothing to suggest that it had received anything, why on earth they'd done that. The point is, at trial and now, the only evidence that we have is that that transaction took place, and as Mr. Fenimore rightly said, that was over a month prior to the so-called asset disposition at the end of July 2017, again about which we know almost nothing and which looks like a very unorthodox transaction indeed. The reason that that's important is that on the 23rd of June 2017, the most recent evidence of value, and it was very recent indeed at that point, is the 2016 JJW Inc. accounts, which is what the judge, of course, based her valuation on, doing the best she could with the evidence she had.
So do you know who are the directors of MBI International Holdings?
I don't think we know. It's a BVI company. There's been talk about it being the Sheikh's children's company, but it's very dangerous, as we've learned, to put any weight at all on things that come from the Sheikh. So I certainly don't submit that that is so. The point I'm making is that for all we know, MBI International Holdings might have taken clear of our beneficial title, applying the principles recently restated in the buyer's case on knowing receipt. And so the shares have been put beyond reach.
Is that obvious? I mean, I quite follow that if they entered into a transaction as bona fide purchaser for value, then you would think that the shares were beyond reach. It seems rather improbable that they were bona fide purchasers for value.
Yes.
If not, you can get the share register rectified, can you? Get the shares back.
My Lord, that would be a different piece of litigation which we haven't brought. And what I would urge upon your lordships to have at the forefront of your mind at all times in this case is that when there's speculation by the Sheikh about, well, I wonder why MBI International Holdings aren't a party, I wonder why JJW Inc. isn't a party, we didn't know that MBI International Holdings had any shares in JJW Inc. at all until less than half an hour before the Sheikh was due to go into the witness box, when he came clean about what had happened. And I would like to pick up something that my learned friend Mr. Crowe said just after the short adjournment in answer to a question that had been posed by the bench in the morning, which was there any evidence before the trial about the shares being registered to MBI International Holdings? And the answer that was given at 2 was yes, there was a copy of the share register. Now, that's strictly correct as far as it goes, but there's rather a lot more to it than that. What was, until the eve of trial, literally the eve of trial, what was before the court was a copy of the share register showing the position on the 23rd of June 2017, i.e. the date that the 891,000 shares were transferred by JJW Guernsey to MBI International Holdings. But crucially, the Sheikh had told us, the Sheikh had sworn to us that all the shares in JJW Inc. had been transferred to JJW UK at the end of July 2017. So the share register showing the position on the 23rd of June 2017 didn't tell us anything useful. And I would invite, I'm not going to take your lordships to it, but I would invite your lordships respectfully to read part of Mrs. Justice Joanna Smith's judgment that she gave on our application to amend midway through trial, which is in the bundle, and that's in supplemental bundle page 156. And if I could invite your lordships in a quiet moment, perhaps to read paragraphs 59 to 70 of that judgment, which go from supplemental bundle page 180 to 183, your lordships will see quite how things emerged, and that her ladyship took the view below that we were quite entitled to have believed that all the shares in JJW Inc., including both the 891,000 tranche and the 129,000 tranche, had been transferred to JJW UK at the end of July 2017. Now, in fact, that was a lie, and we only started to find out on the 1st of February 2021, when there was a flurry of late disclosure, and it was disclosed to us a number of copy share registers. I just need a moment to turn up the exact dates. Yes, so a series of historic share registers were disclosed to us on Monday the 1st of February and Tuesday the 2nd of February 2021. And these showed the position on 30th of September 2019, 14th of January 2020, and the 26th of March 2020, but crucially nothing up to date for the start of trial. And then it wasn't until the fourth day of the trial that the Sheikh actually put some flesh on the bones of this bare disclosure and said, actually, I know I said that all the shares in JJW Inc. were transferred to JJW UK at the end of July 2017. In fact, that wasn't true. The 891,000 were transferred to MBI International Holdings on the 23rd of June 2017, which we already knew. But what we didn't know was that they'd remained in MBI International Holdings thereafter until at least the 26th of March 2020.
I don't know if you're moving on. In terms of the 129,000, you thought those had gone too, did you?
Yes, precisely. And so Mr. Fenimore's submission a few minutes ago, when he said, well, of course, you don't need a crystal ball to see what we would have done with the 891,000 shares, because you just look and see what they actually did with the 129,000 shares, is with respect to my learned friend, is wholly wrong and unfair, because we were told by the Sheikh, he swore to us, that all the shares in JJW Inc. had gone to JJW UK at the end of July 2017. And the passage from the amendment judgment that I've referred your lordships to contains her ladyship's view of that position.
How did you think those 129,000 shares had come from your hands to anybody else?
We thought he had done the same thing that he had done with the 891,000 shares. And for whatever reason, the company's registered agents and JJW Inc.'s registered agents were, JJW Inc.'s registered agents were unwilling to provide us with a copy of the share register. The Sheikh also pretended until the eve of trial that he was unable to obtain copies of the share register from Maples, and that turned out to be wholly false at trial. That completely unravelled at trial, that story, and it turned out that he could get share registers from Maples, the local agents, whenever he wanted to. So that was the position on what we knew about MBI International Holdings at trial, and as your lordships will have seen, we did amend midway through trial, and that's already been the subject of an earlier trip to this court. So it really was, when my learned friend Mr. Crowe referred to the trial as a monster, that is something I can agree with him about. It rather was. Now, one other thing Mr. Fenimore said about this, he in exchanges with my Lord Justice Snowden, Mr. Fenimore was asked why his company, his client, transferred the shares to MBI International Holdings on the 23rd of June 2017, and his answer was, well, it was about a month before the asset disposal at the end of July 2017. I would add to that, it was also exactly a fortnight after we had got recognition in the Chancery Division of the liquidation in this jurisdiction, and it was very clear to the Sheikh by this point that we were pursuing these shares. So really, everything that the liquidator, both Miss Caulfield and those who have replaced her, has been directed at realising these shares, because it has been persistent inquiries, and when progress was not being made in BVI, recognition was sought over here. And the irresistible inference is that it was action by Miss Caulfield that caused the transaction in February-March 2016 to be done, and I'll come on to that chronology in a bit more detail in a moment or two. And it was also pressure by Miss Caulfield's successors to achieve recognition in this country that led to the 2017 transaction. The temporal relationship between the events is absolutely clear. And my lords, the Sheikh's factual case,
from
yes,
which you would anticipate that unless the Sheikh is in the habit of, well, from which you anticipate that there may well be a connection, let's put it this way, at its lowest, between the Sheikh and MBI International Holdings Limited. Sorry, Inc.
Yes, my lord. Yes. His companies, I mean, MBI is his initials, and JJW is also a style used by him. So there is a very significant number of companies that are called MBI something or other, often a sort of a mix and match of the same sort of grab bag of half a dozen words or so, such as International Holdings, Hotels, and JJW. And so it does seem a likely inference that MBI International Holdings is something to do with the Sheikh's empire. But the point is, we don't know. And as I think it was my Lord Justice Snowden who made the point that the person who can dispel all this and who can actually explain why the so-called restructuring in July 2017 was completely a completely normal thing to have done in the ordinary course of business, and it would have happened anyway, even if the company hadn't been in liquidation, and even if the liquidators hadn't been coming after the Sheikh. But he's the one who can lead evidence on that, and we are, the company, is not at all equipped to lead evidence on any of those points. Now, my lords, the Sheikh's factual case at trial was based very largely on an exchange of letters. These letters did not come up to proof at trial, but I'm going to introduce them now. Firstly, there were two demand letters, so-called, dated 22nd of December 2009, respectively from JJW Guernsey and JJAB, and addressed to the company now in liquidation. These demanded payment under the share transfers by 18th of February 2010. Now, on the Sheikh's case, that's the first time that any consideration became payable. A further letter, dated the 30th of June 2010, which has been referred to in the proceedings as the June 2010 letter, that was from the company, and it referred to the IPO as being the only source of payment for the shares, and it says on its face that the share certificates were enclosed to enable JJW Guernsey to effect a retransfer, although of course that couldn't be done with just share certificates. Now, neither of those documents came up to, or sorry, rather none of those documents came up to proof at trial.
But sorry, when you say they not came up to proof, do you mean they were found to have been falsified?
No, we served a notice to prove those documents. There were notices to prove going in both directions in the trial. The documents that the Sheikh wanted us to prove at trial tended to be ones that he, in fact, relied on in closing, showing the sort of opportunistic and shape-shifting nature of his claim. But we served a notice to prove these three documents, and the originals weren't produced. The story behind them was rather incoherent, and the learned judge below found, on balance, that they were not proved. They were, of course, secondary evidence of the documents themselves, and we never saw the originals.
Are the copies in the bundle somewhere?
They are not, but I can.
I mean, they are the documents referred to in the board resolution that Mr. Crowe took us to at the start of the hearing.
Yes. Yes. So they were at least in contemplation by 2016. That's the most we can say about that. But of course, they're dated many years earlier.
Yeah.
Now, the Sheikh's pleaded case, the Sheikh's factual case below, was essentially threefold. One, title to the 891,000 shares did not pass on 18th of March 2009, i.e. the transaction didn't complete and there was a retention of title by JJW Guernsey and JJAB. Secondly, there was a retransfer of equitable title to JJW Guernsey by share transfer.
Sorry, can you just repeat what you just said?
Yes.
Say it more slowly.
Going back to the first point, or yes?
Well, you talked about retention of title. I don't understand.
Yes. So the Sheikh's primary case at trial was that under the 18th of March 2009 share transfers, title did not pass to the company from JJW Guernsey and JJAB. There was a retention of title, at least beneficial title.
Well, beneficial, again, sorry. The legal title undoubtedly did pass.
My lord, yes. I'm sorry. Yes, I was insufficiently clear. Yes, his position was based on a retention of beneficial title. Secondly, the Sheikh's case was that beneficial title was retransferred to JJW Guernsey by the share transfer instruments, which he said at trial, which was found to be a lie, had been executed on the 6th of July 2010. And thirdly and finally, in terms of his pleaded factual case, the Sheikh contended that security arose by the company's deposit of the share certificates with JJW Guernsey under cover of the letter of June 2010. So crucially, the security that was pleaded was a security arising in June 2010. And then at trial, the argument about unpaid vendors lien was also raised at trial. Now, in the interest of time, I'm not going to take your lordships to the first piece of concrete evidence we have of the Sheikh's view of things after those transfers were made, but I'd like to draw your Lordship's attention to the affidavit that he swore in other proceedings involving Standard Bank, dated the 29th of July 2011. That's in the supplemental bundle at page 17. And he's at paragraphs 3 and 4. He makes very clear that all of this is from his own knowledge, and that the implications of what he's doing have been brought home to him very clearly, and that it's a truthful and careful exercise. So that's paragraphs 3 and 4. And then at paragraph 8,
Sorry, page.
page 17 of the supplemental bundle.
Just so I can get my orientation. What's the point of this? Is it just, are these jury points, or which of the issues do these points go to?
These will go to unpaid vendors lien in due course. I'm not going to spend a huge amount of time on this, my lords. It's simply paragraphs 3 and 4, where this is clearly coming from the Sheikh's own knowledge, and he's swearing to it. And then at page 25,
You don't mean page 25?
Yes, top right.
Do you?
yes, it's a schedule that's on landscape view, my lord. So it's
I see.
tab 6.
That's part of this affidavit?
Yes, it is.
Yes,
Yes. And so your lordship will see that here we have a schedule of assets, and then 2 pages on at page 27, there's some shares identified. This is the Sheikh's property sworn for the purposes of an injunction.
Yes, I see.
And we see the name of the company in liquidation at the top, the very first one, MBI International Partners Inc. Shareholding 100%, that means the Sheikh is the 100% shareholder of the company. And owner's equity value, 181 million. And then 2 lines down, we see JJW Inc., JJW Hotels and Resorts Holding Inc., and then shareholding 89%, which of course is consistent with the company owning 11%. And so these values attributed here are essentially what the Sheikh thinks the company and JJW Inc. respectively are worth. And it's a ready inference that the company's value is derived from its shareholding in JJW Inc., i.e. the other 11%. And indeed, the 181 million value indicates that it might actually have rather more than 11% of JJW Inc., but we don't know what that is attributable to. On the 11th of October 2011, the liquidation commenced, and Mr. David Kinnan was appointed liquidator. Mr. Kinnan invoked, against the Sheikh pretty much straight away, Section 276 of the Insolvency Act 2003, which requires completion of a statement of affairs, and a failure to do so without reasonable excuse is an offence. And next, I'd like to show your lordships the Sheikh's affidavit that he swore on the 10th of October 2013. That's at supplemental bundle page 33. This was in support of his application to terminate the liquidation on grounds of solvency. The affidavit is not a good copy, but there is an agreed transcription commencing at page 40.1. That's the last 7 pages behind tab 7. If I could invite your lordships, please, to turn to page 40.6. and the relevant paragraphs are paragraphs 21 to 25 inclusive. In particular, at paragraph 22, the Sheikh says, the importance of the company lies in the fact that it is the 11% shareholder of JJW Inc, which is the holding company of a number of companies in the organisational structure of my network of companies. And then the final sentence about paragraph, the liquidation of the company has caused major disruption to the network's management structure, having a severe knock-on effect on several companies. Paragraph 23, the company is strong and solvent, and the immediate termination of the liquidation is imperative for its commercial well-being and the interests of the public at large of the BVI, and so on. Finally, on this document, at paragraph 25 over the page on 40.7, the Sheikh swears, I have been advised by Harneys that this honourable court may terminate the liquidation of the company if it finds that it is just and equitable to do so, and I respectfully pray that the court will say fine. I am also prepared to undertake to this honourable court that I will not transfer any assets of the company to any other person or entity for a period of 3 years. So this case is about something that the Sheikh did that he offered to undertake not to do if the company was taken out of liquidation.
But it wasn't taken out of liquidation, so therefore his offer of an undertaking wasn't accepted by the court.
That's right, yes. So I don't suggest that he gave the undertaking, but what I do suggest is that he was clearly swearing to the court that the shares were valuable and that the shares gave rise to a solvent position in the company, and that the shares, this is the real point, my lord, that the shares, the value of the shares would be available to the company's creditors if it was released from liquidation. Now, of course, the asset position of the company has to be the same for all purposes, whether it's in liquidation or not. If the shares were to be available for the creditors outside the liquidation under the Sheikh's control, then they should remain available to the creditors if the liquidation is
so is your
continued.
point that he couldn't have said that truthfully if there was an unpaid vendor's lien?
My lord, yes, or any form of security, or any of the other forms of argument that he's put forward. Yes, I mean what we say is that his actions in BVI, what he said in BVI during this litigation process, was ultimately unsuccessful for him. It is a waiver of any unpaid vendor's lien. Well,
how could he waive it? I mean, it's one thing to say that he doesn't seem to think that there's an unpaid vendor's lien, but I mean, why would this amount to waiver on behalf of the two companies that would have the unpaid vendor's lien if one existed?
Yes, well, he's the sole. I think he's the sole shareholder at this time of JJW Guernsey, and the controlling mind of that company. That's an unappealed finding of the judge below, and so anything what he is doing in BVI is to be imputed to JJW Guernsey as well as the company. A striking feature of this case, my lord, is that when it's helpful to the Sheikh, such as when he's asking for what he describes as an administrative oversight or something of that nature to be overlooked, he says, well, of course, I was in control of all the contracting parties, so it doesn't really matter that that I's haven't been dotted or T's haven't been crossed. That's my paraphrase, not his words. But then when he's trying to dishonestly misappropriate assets or mislead the court or lie to the liquidator, then there's a very rigorous silo-based hat-wearing approach, if I can put it that way. Oh, he wasn't wearing his JJW Guernsey hat that day. It's completely unreal, in my respectful submission. The whole tenor of what went on in BVI is, even if not a complete waiver, it's at least a postponement to the interests of the creditors, of the kind that Lord Millett talks about in the Barclays case that we'll come on to a little later on. Mr. Justice Bannister refused the termination and in the interest of time, I won't go to it. But his judgment is very perceptive in what might happen if he terminates the liquidation in relation to the assets remaining available for the creditors. And I don't think Mr. Justice Bannister would have expected the assets not to be available for the creditors if he allowed the liquidation to continue, and indeed he did. But essentially, the hazard that Mr. Justice Bannister had in view when refusing to terminate the liquidation is the very thing that has transpired, even within the liquidation. 31st of March 2014, Mr. Kinnan was replaced by Miss Caulfield. As the judge found, Miss Caulfield wrote to the Sheikh on the 23rd of June 2014 seeking to protect the company's assets. That's paragraph 82 of the judgment. On the 1st of July 2014, Miss Caulfield invoked Section 275 of the Insolvency Act 2003, which is the requirement on pain of committing an offence to complete a statement of affairs. That's at page 44 of the supplemental bundle. There was then extensive chasing over the summer of 2014. That's at paragraphs 83 to 87 of the judgment. Then in September 2014, the leading counsel in the BVI, Mr. John Carrington, QC, as he then was, prepared appeal submissions on behalf of the Sheikh, appealing for Mr. Justice Bannister's decision not to terminate the liquidation. Those submissions asserted that the company was not insolvent and that the assets would be available to the creditors. The Sheikh, in his supplemental skeleton in this appeal, tries to make something of the fact that the value attributed to the company is only Mr. Kinnan's assessment, but that ignores the fact that it's based on the Sheikh's own evidence that we just looked at, the sworn affidavit of 2013. On the 31st of December 2014, the Sheikh signed the Statement of Affairs, finally, and after considerable chasing. It's expressed as being sworn. It refers to an investment in a subsidiary. The judge found that the fact that it's recorded under the heading pledged does not mean that Miss Caulfield realised that or should have appreciated that the shares were said to be subject to security. That's judgment paragraph 242. Importantly, in fact, I will take your lordships to this document if I may, very briefly before we conclude. As paragraph page 60 of the supplemental bundle. JJW Guernsey is recorded as a creditor on this document. So it is not that JJW Guernsey has been somehow overlooked. JJW Guernsey is recorded as a creditor for $10 million US. That information, of course, came from the Sheikh, and so again, I submit that the proposition that the Sheikh isn't wearing a JJW Guernsey hat, essentially, while doing these things, is unreal. He's acting as a director of JJW Guernsey in identifying what the creditor claim of that company is, or at the very least, as controlling mind of JJW Guernsey, he is standing by while he himself, wearing a different hat, says that JJW Guernsey is a creditor for 10 million only in this document.
I mean, the asset estimated to realise value is the net value.
Yes. Yes, the Sheikh applies an exactly the same approach to valuation as does the judge in awarding us compensation, save that the Sheikh takes the value, purportedly takes the value at the date of the commencement of liquidation.
But that's making the point that the amount available for unsecured creditors is $134 million US.
Yes, that is essentially the liquidator's case. Yes, my lord. So he's taking a net asset value with no discount, just dividing it by 11%. which is, you know, what's sauce for the goose is sauce for the gander, my lord. It's what the liquidators say.
Sorry, I don't quite understand that, because how does one know that that's just a pro rata?
Yes, at trial, this is where the suggestion of
No, I'm talking about off the face of the document, because off the face of the document it simply says investment in subsidiary, 11% shareholding, and it gives it a value.
Yes.
It gives you no idea how that value's been arrived at.
My lord, at trial, there was an earlier iteration of this document that had been heavily amended by the CFO of the Sheikh's Empire, Mr. Falak Yusuf, and that showed the arithmetic in Biro, showing that this was simply a pro rata valuation, and then it was carried across, the same numbers that he had written in Biro, were then carried across into this final document that the Sheikh then swore, or expressed as having swore. And while I'm on this document, there was a suggestion that this is derived from a mistake. That seems to be a slip by the judge, because earlier on in the proceedings, Mr. Kinnan got JJW Guernsey and JJW Inc. the wrong way round. But this document, it's very difficult to see what the mistake was said to be. And in any event, the Sheikh swore it. So there we are.
And more to the point, there doesn't seem to be any acknowledgement that there's a lien over the shares.
Certainly not. No, quite the reverse. And if I could just, I know the court is right. If I could just finish this document, my lord, it will take 30 seconds. The next page, page 61, my lord. It's a schedule of creditors. At the top, note: you must identify creditors under hire purchase, chattel leasing, or conditional sale agreements, and customers claiming amounts paid in advance for the supply of goods or services, and creditors claiming retention of title over property in the company's possession. Of course, the Sheikh's factual case at trial was that there was such retention of title or a conditional sale. JJW Guernsey is identified there as a creditor for 10 million. In the column 3 from the right, details of any security held by creditor, none. My lord, is that a convenient moment?
Yeah. So we'll start again at 10:30 in the morning.
All right.